Well, hello and good morning. Welcome to another Sunday morning coffee with Dr. Childres here. Now, in today's video, I'm going to be speaking directly to the attorneys for the targeted parents regarding the pathology in the family courts, describing my role in the family courts, the various services or consultation services I provide, and a little bit about your role with the targeted parent. So, to begin with, just to describe um, my role in the family courts, when I'm brought into a matter as a consultant in clinical psychology, I have two clients. The first client is always the child. As a clinical child and family psychologist, the child is always my client. In addition, though, when the court's involved with my child client, I obtain a second client, and that's the court, who will be making significantly impactful decisions regarding my child client. So, my first obligation to my child client is to ensure that the child receives an accurate diagnosis and effective treatment plan to fix the problem. Because if I fix the problem for the child, then I satisfy the parent's goal, which then satisfies the attorney's goal. So my focus is on getting the child an accurate diagnosis and an effective treatment plan. Now, my obligations to the court is to ensure that the child receives an accurate diagnosis for the court's decision making surrounding the child. And if I'm of value to the court in its decision making, then I'm of value to the parent and the attorney. So basically, um, my role is the same. I'm a consultant clinical psychologist. I'm a uh, doctor of psychology, and my job, my role is to ensure that we get an accurate diagnosis and an effective treatment plan to fix the problem. I don't care what the problem is. I don't care if it's ADHD, autism, trauma, child abuse by the allied parent, child abuse by the targeted parent. I really don't care. My job is to get an accurate diagnosis. What's causing the problem so we can develop an effective treatment plan to fix the problem. Now, with this particular problem, my concern is possible child abuse, one way or the other, targeted parent or allied parent. So we need to get a proper risk assessment for child abuse because we're very likely to have a child protection issue involved when a child is rejecting a parent, seeking to flee from a parent. So again, my focus as a clinical psychologist in the family courts is in obtaining an accurate diagnosis to create an effective treatment plan to fix the problem. Now, we need an accurate diagnosis because that is necessary for treatment. The treatment for cancer is different than the treatment for diabetes. And so, if we try to wind up treating cancer with insulin, the patient's going to die from the misdiagnosed cancer. So, in healthcare, all of healthcare, we need an accurate diagnosis on which to base our decisions and which to base our treatment. Now, we need effective treatment because that's the goal. The goal is not the custody, the goal is to fix the problem. And the problem is we have a child who's rejecting a parent. We got attachment problems. We got something going on that's a problem in the love and bonding system of the brain, the attachment system. The legal system lands on the wrong endpoint. It lands on the custody decision. The proper endpoint is in healthcare. It's fixing the problem. So let me say something about that. The narcissistic, borderline, dark personality parent, which is what we're worried about, it's highly manipulative. They are driving this into the wrong system for a solution. They're driving it into the legal system because they can manipulate the legal system. What they can't manipulate is the healthcare system of getting a diagnosis about what the cause of the problem is. They don't want it in the healthcare system. They don't want to fix the problem. They want the problem. They are creating the problem. So they want it over in the legal system where they can keep it all going on and trying to prove pathology to a judge and trial and things. We need to get this into the proper system for a solution. This is not a crime. This is a pathology. We need a diagnosis and treatment plan to fix the child's problem and the family conflict and everything. We need an accurate diagnosis of what that is. So again, the focus of the legal system is on best interests of the child. It is always in the child's best interest to fix the problem. So in my role in the family courts is evidence. Now in the healthcare system, I'm the authority, I'm the doctor, and I have duty of care obligations. So when I give a diagnosis, it's accurate 100% of the time. And if you don't agree, get it out to a second opinion for a challenge. But my diagnosis is accurate 100% of the time because it needs to be. I was trained at Children's Hospital of Los Angeles. And so I'm working as a pediatric psychologist on a medical team. And the doctors at Children's Hospital, when you're diagnosing something, some sort of medical problem, your diagnosis needs to be accurate because if you misdiagnose the pathology, very bad things happen to the patient. Okay, so I'm trained to the standard that the doctor's diagnosis needs to be accurate 100% of the time. And if we don't know what that is, then we go get consultations. We identify what information is needed. We collect that information so our diagnosis is accurate 100% of the time. Now, that's my role in the healthcare system, is as a doctor to ensure that. Now, in the legal system, though, I cross a boundary and I'm no longer in that role. I am evidence in the legal system. I am not an advocate. The legal system has advocates. They're called attorneys. My role in the family courts is to apply the established knowledge of clinical psychology to a set of information from either document review or direct assessment. And then I allow the attorney to present the evidence of the applied knowledge from clinical psychology for the court's consideration in its decision making. The forensic custody evaluators did a very bad thing by going off and trying to help the court in its custody decisions. That's not the role of a doctor, that's the role of the judge. The doctors need to stay within our role, which is diagnosing and treating pathology. Our obligation is to return an accurate diagnosis for the court's decision making and then to effectively treat the problem and fix the problem. That's our role as doctors. So just my background expertise, why I'm working in the family courts and how you can bring me onto your matter and why you would bring me onto your matter is that I have specialized expertise in a variety of domains that are all supported by my vita. First, clinical psychology, child family therapy. Been doing that my 20, 25 years of child and family therapy. And I'm a full spectrum psychologist, so I have background in ADHD and autism, high quality background supported by my vita, as well as child abuse and complex trauma. And I'm qualified under Cadence law. So let me say something about that for a second. So not only do I have broad background, I was the clinical director for a 3-university assessment and treatment center for children ages 0 to 5 in foster care. So, and I have early childhood mental health background. So I have attachment background, I have complex trauma, I have child abuse background, and broad scale clinical psychology background, working with Jim Swanson on ADHD and top people there, and over in autism, early childhood background. So I understand everything about child and family therapy. Now, in addition, though, Cadence law is moving through a number of these states, and it restricts the experts that can testify in the courts to only those that have direct clinical experience with child abuse. I have direct clinical experience with child abuse, including sex abuse, so I qualify as a testifying expert under Caden's law. Now, in addition, I have attachment expertise, early childhood mental health. I know two different diagnostic systems, for early childhood. I have know two treatments for early childhood attachment pathology, and I'm certified in Field and Graduate Institute in infant mental health. So I know the attachment system. And let me say this: a child rejecting a parent is an attachment pathology. It's a problem in the love and bonding system of the brain. And so that's the attachment system. So I have that background, and that's pretty much the only place you get it is early childhood. So I bet you none of the mental health people in the family courts have attachment background. In addition, none of them have delusional thought disorders. I have 12 years working at UCLA and diagnosing delusional thought disorders. And that's what the pathology we're worried about is, a persecutory thought disorder. So I can pretty much guarantee none of the current mental health people in the family courts have expertise in delusional thought disorders, nor do they have expertise in factitious disorder imposed on another. I do, out of my background at children's hospitals, and I have 15 years of experience in court-involved custody conflict. So when people say, what type of mental health person should I be looking for to conduct the assessment or treatment? You won't find them. There's your qualifications: attachment, early childhood, delusional thought disorders coming out of schizophrenia, child abuse and complex trauma, family systems, factitious disorders, and family court pathology. Find all of that. You won't. I have it. Okay, that's why I'm brought into these situations, because I'm competent and they're not. And that's deeply unfortunate for the involved mental health professionals, that they are not getting competent, that they're just kind of lazy and ignorant. Now, my role, what I do in the family courts, I basically have three roles. And this is for my sanity. I kind of organize my world and my consulting practice into three main scope of service agreements. The first thing I do is document review. And that can be, oftentimes it's a custody evaluation, but there's lesser documents such as treatment reports, GAL reports, things like that. The second type of task that people bring me in on is as a telehealth second opinion on an active assessment. That's my preference. The third role that people bring me in on is more general professional consultation to sort of help organize the mental health approach, work with the involved professionals, and move a situation in the proper direction. So let's talk about my consultation on document review. That's mostly correcting a problematic situation. So my document review, I'm typically brought in on a forensic custody evaluation. And for that, that's a 50-page forensic custody evaluation, sometimes longer. And what I will do is a line-by-line review of that to collect my notes, because of both the symptoms described, but also the ignorance involved is so dense that I extract it line by line. So both the critique of the forensic evaluation line by line, and also extracting the symptom evidence line by line. Because let me say something about that. The forensic custody evaluations basically just audio record their interviews and present that as the family history and symptoms, which is incredibly low practice. But it gives good documentation of what the symptoms are. Everybody's just reporting the symptoms. And diagnosis is simply a pattern match of the symptoms to the diagnostic criteria. So as I read the symptoms reported in the forensic custody evaluation, I just apply the diagnostic criteria to that and go, we're looking at, a persecutory delusion here, and child abuse and factitious attachment pathology and all this kind of stuff. But I can't make the diagnosis because I don't have duty of care. It's not my obligation to make the diagnosis. I need to talk with everybody and confirm the diagnosis through various interviews. Now, But again, it's just a pattern match, similar to what the judges do in the legal system. You apply the evidence, the symptom or the evidence that's presented to the court, and you apply the legal statutes to the evidence, and to find out, make your verdict, guilty or innocent. We apply our diagnostic criteria to our symptom evidence to identify the diagnosis involved. So a lot of times I'll be doing a custody evaluation, a document review, and they don't diagnose pathology, which proves to be highly problematic. So I do a line by line. Those become my Appendix 1 notes. Then those line by line notes also generate a more general catalog of concerns. That's typically around 25 pages or so, 30 pages. And those are more general difficulties. And typically what I'm doing is I'm layering up the support for the ultimate opinion, which is going to be in about a 25-page summary and analysis report. So that's going to be the summary and analysis report is going to put everything together for the family. Now, the catalog of concerns will support some of the concerns about the forensic custody evaluation, if there's board complaints or malpractice or other things going on with that, as well as the line-by-line Appendix 1 notes that will support all my opinions in the summary and analysis report. And the additional thing about the line-by-line notes is it gives the attorney specific places to go on their cross-examination of the forensic custody evaluator, and I'll help with consultation on cross-examining mental health testimony. But you can go right to the custody evaluation and know exactly where the problems and where the symptoms are that are of concern. Then I do testimony on that as part of that whole scope of service agreement, as well as consultation with the attorney and the parent clients, and again, consultation on cross-examining the mental health testimony. Now, the problem with document review is, though, that we still need a diagnosis to guide the treatment and guide the court's decision-making. So while I can correct a situation and I can get you really close to the diagnosis and I can tell you exactly where we need to go and exactly what we need to look at, we still need to do that. We still need a diagnostic assessment. And an effective treatment plan is the goal. The goal is not the custody decision. The goal is to get an effective treatment plan. And to do that, we need an accurate diagnosis. If we treat cancer with insulin, the patient dies. What's the diagnosis? My concern is it's a bit of misdiagnosis of a possible delusional thought disorder in the alive parent and child psychological abuse. So a document review can help correct a situation that's going badly and place it back onto the proper path of diagnosis and treatment. However, we will still need a diagnosis and treatment plan because we still need to fix the problem. So let's talk about that. That's my second rule, which is consultation on an active assessment, obtaining an accurate diagnosis. Now, let me just say something about that. If you think about the healthcare system, doctors consult all the time. That's what we do. You say, doctor, this hurts. They say, let's get an orthopedic consult. The only place that doctors don't consult is in forensic custody evaluations because everybody's legal and fighting and everything, and the forensic psychologist left healthcare and became quasi-judges and trying to decide on custody rather than stay focused on treatment. Doctors, in my opinion, the problem in the family courts is that doctors stopped being doctors and tried to be mini judges deciding on custody or custody evaluations. Doctors need to go back to being doctors, which is what I do. I diagnose and treat pathology, and we need to come up with an accurate diagnosis and effective treatment plan for the problem. So, in healthcare, this is the second opinion healthcare, telehealth consultation. This is my recommended solution to the problem. in the family courts generally, this is a structural solution. Whether I'm here or not, I recommend this is a solution we need to move into, which is a return to the healthcare system, return to diagnosis and treatment. The appellate system in healthcare for a disputed diagnosis is second opinion. Any diagnosis returned into the legal system will be a disputed diagnosis, as it should be. The legal system challenges evidence. Both parties are allowed to challenge the evidence. So you bring in a diagnosis, that should be challenged. Is it an accurate diagnosis? And the appellate system is a second opinion. So the solution is for the court to appoint a primary, hopefully treating psychologist, and the court should identify who that is to conduct the diagnostic assessment. And then each litigant parent should be allowed to appoint a second opinion consultant through telehealth for that assessment. And that will guarantee that we get the assessment conducted and that the rights and issues and concerns of both litigant parents are properly addressed in that assessment through their consultant. And so you put 3 doctors on it, or 2 doctors, or get a second opinion consultant on that. And you let the doctors do what the doctors do to diagnose and come up with a treatment plan, and then you present that to the court as the evidence for the court's decision making. And so here's what that looks like in a diagram. So you have 2 litigants. Litigant 1 is alleging child abuse by the targeted parent. Litigant 2 is alleging child abuse by the allied parent. So what is it? Is that subject to trial? No, judges don't diagnose child abuse. Doctors do. We're one side of child abuse. The allied parent is worried about something abusive by the targeted parent, and the child's symptoms are trying to flee a parent. That would suggest abusive rage parenting. Meanwhile, the targeted parent is saying it's a false or factitious disorder imposed on the child. It's child psychological abuse by the allied parent. That needs to get out to the mental health system for a diagnosis. So we get the clinical diagnostic assessment. Each party is allowed to appoint a telehealth second opinion consultant to that. Then we get the report from the doctors with dissenting or concurring reports, and then the court can make its decision based on the reports of the doctors. And then we go into the treatment plan based on that decision. So that right there is the solution for the courts and the mental health system. It's not about custody, it's about diagnosis and treatment, and it's how does the healthcare system respond to a disputed diagnosis, second opinion. So rather than getting it sequentially, let's get it all right up front, because we need to stop arguing about these children. So here's what it looks like from a more procedural approach. Is we have 2 systems, legal system and healthcare system, and they work in parallel. So we have attachment pathology enter the legal system. That's not a legal issue, that's a healthcare issue, but it affects the court's decision making. So we get it out to the healthcare system. The healthcare system then conducts a proper assessment, returns an accurate diagnosis, and a proposed treatment plan. Then that goes back into the legal system as the evidence for the court's decision making. The court makes its decisions, and then we move it back into the healthcare system for treatment, and the diagnosis guides the treatment. Okay, so there's your solution for what needs to happen in the family courts. Here are your 4 diagnostic questions that need to be answered in every case. If you bring me onto a situation, I'm going to want to know what are the answers to these questions. This is fundamentally, I need answers to these questions. We need them. The court needs them. Child needs them. Everybody needs an answer to these questions. First question. Is the targeted parent abusing the child in some way, creating the child's attachment pathology towards that parent? If yes, specify the type of child abuse. We're going to put it on a treatment plan, fix it, and restore the child's bond to the targeted parent. Is the allied parent psychologically abusing the child by creating a shared or induced persecutory delusion in the child? Okay, I need that answered. Is there a persecutory delusion shared, induced? In addition, Is the allied parent psychologically abusing the child by creating a false or factitious attachment pathology in the child for secondary gain to the parent? And let me talk about the secondary gain. That's a factitious disorder imposed on another. In the family courts, the secondary gain, the reward for the pathological, narcissistic, borderline, dark personality parent to produce pathology in the child, the reward is there's three of them. First, manipulating the court's decisions on child custody because of the child's induced pathology. Second, spousal abuse of the targeted parent using the child and the child's induced rejection as a spousal abuse weapon. And third, as a regulatory object to meet that parent's own emotional and psychological needs. So we have the secondary gain to produce false pathology in the child, and that we need an answer to that question. Is there a factitious disorder imposed on the child? Fourth question, is the allied parent using the child as a weapon of psychological spousal abuse of the targeted parent? Okay, so I got 4 questions. 2 primary questions, is there child abuse and is there spousal abuse? So we got abuse on the table. So we need to get a proper assessment, because no matter what we're looking at potentially, very potentially, a child abuse diagnosis by one parent or the other based on the child's symptoms. Now, if we take a look at that other diagram and turn it on its side and extend it out into treatment, then this is what the diagram looks like. So those consultants to that initial assessment that each party was allowed to appoint can also serve as consultation resources for the mental health treatment providers to ensure successful treatment. So here, going from left to right, we see the court. We have 2 litigants. The court orders the diagnostic assessment. The 2 litigants are allowed to appoint second opinions on that, returns the diagnosis. That goes back into the court's decision-making, as well as guiding treatment. And then the 2 consultants can continue their consultation on the treatment to make sure everything gets fixed. Okay. And so that right there is the healthcare solution to the problem. Now, what's happening in the family courts is the forensic psychologists tried to create a legal solution to the problem. And they went into the doctors went into the legal system trying to assist the court on its custody decisions. Bad choice, wrong thing to do, and it failed for 40 years. We need to get back to established healthcare, diagnosis and treatment, and this would be the healthcare solution. Second opinion, get an accurate diagnosis, put it on a treatment plan, and fix it. That's the healthcare solution. So now, in terms of engaging that third, so there's my 2 roles: a document review where I do line by line and a summary and analysis report, or active participation, second opinion consultant on an active assessment. The third role is just general clinical engagement and consultation, interfacing with the involved professionals. So, sometimes you will have we may not have a custody evaluation for document review, or the assessment is not currently underway or things, but we have a lot of involved professionals. We have GAL people, we have parenting coordinators, we have therapists, child therapists, we have a bunch of people involved. And so I'm sometimes brought in to help organize that situation, organize how it's moving, and move it towards getting an accurate diagnosis and effective treatment plan. We got professionals involved. Let's get an accurate diagnosis on this. And a lot of times the pathological parent is so flamboyant in their pathology, everybody kind of realizes what the problem is, but nobody knows how to fix it. So I'm brought in to help organize how to fix it. So what this does, this role engages my involvement. I estimate about 10 hours of my time. Actually, it's going to be more. I'll tell you about that. But it's for 10 hours of my time. The other 2 are for 20 hours of my time. And so what I will do in this role is I will consult with the attorney, GAL, minors counsel, family therapist, individual therapist. I'll review documents, treatment reports, and court declarations. Those are like 3 or 5 pages, sometimes 10 pages. They're not like a forensic custody evaluation, 50 pages and stuff. I will still do a line by line on them, and a summary and analysis report, depending on how appropriate that is. But I will review documents within the scope and provide letters and reports, as well as collaborating with the involved professionals to achieve movement in the proper direction, the diagnosis and treatment, potentially moving into future involvement on assessment. So if it moves into assessment, then I may be a consultant on the matter or pre-consultant in helping to organize what the diagnostic questions are that need to be answered. So in terms of my supporting the involved mental health professionals, I've also given you online support. Okay, these video seminars, like I'm talking to you now as the attorney. I speak with the GAL, with a family therapist, with with the court, with the involved professionals around, and these are up on my YouTube page of my consulting website. So there's a whole sets of group of things, and then the videos that correspond to that. And so the ones I want to point out is particularly speaking with other professionals. And so there's a set of videos in there where I speak to the various involved professionals with the family. And you can provide these to the various, if you got a GAL, ask them to watch the GAL thing. And so I can talk with them directly. You can ask them to talk with me. I've done that. And so just ask them to get on the schedule. Maggie will get them on my schedule, and I'll provide a consultation to the GAL person or to the parenting coordinator or to the family therapist or to the individual. I'll talk to anybody who is authorized on their end to talk with me. And because I don't know who the client is, if I don't know who the client is, there's no confidentiality issues. So pretty much they're all authorized to talk with me as long as they're not disclosing confidential information, and that they're not. They are acquiring information. But if they don't want to talk with me because it's a court and everybody's like sides and stuff, then they can just watch the video and I'll talk to them. It's a one-way movement of information. I'm trying to educate them. People talk about what do we need education in the court system. I'm providing the education in the court system, so use it. Okay, stop asking, what should the education be? This, right here. This is what the education should be from clinical psychologist, doctor, work in the family courts, expert in all these things. So educate yourself. So that's what these seminars are. So I will talk with all the professionals. Then in addition, I have Dr. Childres answers your questions. Now, you're an attorney. If you email me a question, I can answer it on Dr. Childres answers your questions. Okay, so if you want an answer to a question, I can give you a little video on that. You can propose a hypothetical. Now, how about this? Propose a hypothetical, present it to me, and I'll answer your question up on a video, and then you can have the involved therapist watch the video on your hypothetical question. Okay? So there's plenty of options that we have for getting this information to the involved professionals. In addition, I want to point out my diagnosis series. That is where I describe at a professional mental health level how to diagnose the pathology. So I have seminars on diagnosing the persecutory delusion, the factitious disorder, the child psychological abuse, the parenting skills generally. So that's my diagnosis series that I recommend everybody in the family court watch, including the courts. And then also I would just know Sunday morning coffee with Dr. Childres and Blue Sky, which is what I'm doing today. Okay, so you can just, every Sunday I have another coffee talk, so you can just grab it and pay attention to it. And it's all up on my YouTube channel. I separate some of those out and put them on my consulting channel. But you can check in and see what the week's Sunday coffee is about. Plus, I'm on Blue Sky. And so I suggest you follow me on Blue Sky. I suggest your GAL follow me on Blue Sky. Your parenting coordinator, your child therapist, follow Dr. Childres on Blue Sky. It's easy. You should get the information. And I will announce on Blue Sky what my Sunday coffee is about. So if you want to attend to that, you can attend. They show up on Facebook. They go to my YouTube channel. Then, in addition, I have the 2 seminars from California Southern University, Master Lecture Series from 2014 and 15, I think, that describe the pathology in detail at a professional level. So those are your more fulsome descriptions of the pathology and what's going on in the family courts. So let's talk about my fee structure. As a psychologist or as an attorney working with your client, if you bring me on to a matter, what are we talking about? So I bill, first off, we would develop a scope of service agreement where you would provide me with what you want. What role do you want? Document review, participation in assessment, helping to organize your mental health situation right now, and what would I bill for that? But I cap my hours, and I bill to the agreement, not to my hours. And so initially when I came into the family courts, I was billing on my hours, and that just got too crazy for me because I have all these clients coming in and keeping track of stuff, and I'm a psychologist, not an accountant. And so what I did is I basically blocked it off into these 3 roles. And I'm giving you a set number for those 3 roles. This role is going to cost this. This role is going to cost this. This role is going to cost this. And I do that for a couple of reasons. One is it saves my sanity to a large measure. And also, though, I want to give the targeted parent or client a set number. If you bring Dr. Childres into a matter, this is your budget for him. Boom, boom, and that's it. Because these parents are getting hit so hard financially. Not only are attorneys extremely expensive, then when you put it into trial, that becomes extremely expensive. In addition, they've got family therapists, child therapists, potentially GALs, parenting coordinators. They just stack up people on the payroll of these targeted parents, and then I become another one. So I'm trying to both limit my costs, and you'll see that in a second. I'm trying to limit my costs and also provide them with something that's concrete. You bring Dr. Childres in, this is what and that would be negotiated or discussed at a scope of service agreement, you, me, and your client. In my online office, we develop that agreement. Now, for document review, my package or the cap on my hours is 20 hours. So that's what I bill. I bill for 20 hours of my time. Now, what I do is I line by line, Appendix 1 notes, and the catalog of concerns. That takes me about 20 hours, typically about 2.5 days of just focused time going through line by line. Then my reporting hour, my report takes me about 10 hours. That's about a day and a half. Usually, sometimes more, sometimes 2.5 days. Then my testimony, I allot 8 hours for testimony. That's included as part of this. So I figure about 8 hours of testimony because it's cross-examination and stuff. And then consultation with the attorney and the client for about 4 hours, beforehand, during, after, that kind of thing. So you can see there, the amount of hours I'm spending is like double what I'm billing for. But I'm trying to keep costs down for the mental health, for the parents in the family courts. So then again, with the telehealth second opinions, scope of service agreement, we talk about what you're looking for and what I can do. I cap my hours, I bill to the agreement, and for a telehealth second opinion, I bill 20 hours. Okay, so you're on that level. I'm either doing an assessment with you or I'm doing a document review. We talk about it, and my fees are for 20 hours of my time. Now, for the telehealth participation in the assessment sessions, that's about 12 hours. That's going to be an hour and a half for likely 6 sessions. as well as I will keep detailed notes. And so, because those notes are going to go into court potentially, so I will participate in the session and then take my notes, and then consult after the session with the other consultants. Now, the consultation with other professionals would be about 3 hours. We'd consult for an hour ahead of time. We can consult somewhere for about an hour during the assessment. As we get information, it starts to get clear, and kind of talk about where we did and where we're going with the final. And then a consultation at the end, kind of where our ideas are about the pathology at the end. And then report writing, again, 10 hours, probably more than that. Testimony, I would figure 8 hours again for testimony, and then consultation with the attorney is for 4 hours. Now, all of that is included within the scope of service agreement. And the other reason to do that, from my perspective, is by billing to the package. Once you get my involvement, all those consultations I'm not billing for. So if the attorney and the parent want to get a hold of me for something and talk about some situation that's developing, get a hold of, talk to me about it. It's not going to cost, there's no barrier to talking with me as your consultant. And that's what I want to do. I'm working for the child. I have 2 clients, a child in the court. I'm working for the child. We need to get an accurate diagnosis and effective treatment plan. That's my scope of service. That's what we need to do. So then the professional consultation role, again, scope of service agreement. I cap my hours. I bill to the agreement. And then the professional consultation is 10 hours of my time. So you figure, and this is more about it, first to engage my attention to the matter, because I have stuff coming in and going out. But when you bring me on as a consultant with this, retain me as a consultant for your mental health services, I'm now attending to your situation. So it engages my attention. I consultation with the other professionals, maybe about 4 hours of working with GALs or therapists or people. Document review, report, and letter writing. Now, this is not a custody evaluation. This might be treatment reports, GAL reports, declarations from the court, things like that. So document review and letter or report writing, probably about 8 hours on that. Testimony would be 4 hours estimate, and consultation with the attorney throughout this and their client is about 4 hours. So again, you see my actual hours are probably twice what I'm billing to. You couldn't afford me if I just billed to my hours. And then finally, what I want to sum up here is that as the attorney for your client, for this parent, that your role, in my opinion, is as the zealous advocate. And let me talk about that for a second. That zealous advocate is contrasted with another role attorneys typically fall into, which is the litigator. That's seeking agreements. So you're helping people form agreements and get along, versus the zealous advocate role. And previously, the attorneys for the targeted parents have been in the litigator role because you haven't had the evidence to support a zealous advocate role. You're trying to reach agreements and to get the court to cooperate on separating the child or doing something, So that's a difficult role for you to be in. We need to switch you over to the zealous advocate role for a couple of reasons. The first and most primary reason is the pathology is child abuse of the client parent's child. So they need an attorney who will fight like gangbusters to protect their child from child abuse. So first, there's not an agreement. We're in a child protection zone. The second reason is because the pathology is the emotional and psychological spousal abuse of your client parent by the other parent using the child as a spousal abuse weapon. So again, we need you as a zealous advocate stopping the spousal abuse and the child abuse with your client parent. So they need, the child and your client parent need a zealous advocate, not a litigator. It's about child protection, spousal protection. However, or in addition, to be a zealous advocate for child protection, you, the attorney, needs the supporting mental health information. And that's why I come in. My focus is on my mental health people, the healthcare system, diagnosis, DSM. I don't use made up pathology. We're into the DSM actual diagnoses, and the concern is child abuse. And my role is to get that solid, accurate diagnosis for the pathology that you can then present to the court for the court's decision making, and that we can then move into the treatment and work with the treatment providers to get effective treatment to fix the problem. That's what we need to do. There's no other alternative. The child is rejecting a parent. Well, we need to fix it. Period. Okay, so I just need to know who's causing the problem, and then I can fix whatever that problem is. We need an accurate diagnosis on that. So with that, there's my contact information. Feel free to get a hold of me. I have scheduling. You can schedule through my website, but as an attorney, just email me and we'll get you on my website. If you know what you want, and that's going to be my question when you talk with me, what are you looking for? We have a custody evaluation. We'd like a second opinion on that. And okay, we would like you to bring you in as an assessment, or we would like some hybrid. Let's bring you in as a consultant here, and then we'll talk about these other factors as well. That's a scope of service agreement. We'll talk about those situations. If you have a question, if you have a hypothetical question, feel free to email it to me, and you may see it pop up on a Sunday coffee talk here. And I would recommend you follow me on Blue Sky. I recommend your GAL, your judges, everybody follow me on Blue Sky to get your judicial education, your mental health education, your everybody education. I'm available. And all your mental health people and support people can get a hold of me. Just give them my email address, get them on my schedule. I do that. Or just get them my videos where I explain everything. Okay, so I'm available with the family courts. Thanks for taking the time, and hopefully we can get this solved for your client and for the child. So with that, I'm going to head off to my son.